If you've ever wondered what you're supposed to do when a police officer walks up to your car and tells you to unlock your door, stay with me, because by the end of this video, you'll know the exact phrase that can help protect your rights, avoid common mistakes, and prevent a simple traffic stop from turning into something much bigger than it ever needed to be. Picture this. You've had a long day. You're driving home, thinking about dinner, your family, or maybe just getting off the road and relaxing. Then suddenly, flashing red and blue lights appear in your rearview mirror. You pull over. Maybe you forgot to signal. Maybe one of your taillights is out. Whatever the reason, it seems like a routine stop. The officer approaches your vehicle. You lower your window and hand over your license and registration. Everything appears normal. Then something unexpected happens. The officer reaches toward your door handle and tells you, "Unlock your door." At that moment, most people don't realize they're standing at a crossroads. What happens next can make a huge difference. The response you give could be the difference between handling a routine traffic matter and opening the door literally and legally to a much deeper investigation. The problem is that the response most drivers give in that moment is exactly what creates complications. People think they're being polite. They think they're showing cooperation, but in many situations, they're unknowingly giving the officer something that can later be interpreted very differently. In this video, I'm going to show you the exact words you can use when this situation happens. We'll also walk through the legal principles behind those words and discuss several court decisions that help explain why this issue matters so much. And make sure you stay until the end, because even if you do everything correctly, there is still one common tactic officers may use to try to get around that boundary, and you'll want to know how to respond. Here's what many people never realize. When an officer tells you to unlock your door, it may sound like a simple instruction, but in many cases, it's also an opportunity to see whether you'll voluntarily give up a layer of protection that currently exists between you and the interior of your vehicle. Think about it from the officer's perspective. During a traffic stop, they often don't know whether the driver understands their constitutional rights. They know many people want to appear cooperative. Most drivers don't want conflict. They don't want tension. So when an officer asks for something, people naturally feel pressured to comply. As a result, many drivers immediately reach over and unlock the door without giving it a second thought. The issue is that prosecutors may later argue that this action demonstrated consent, or at least implied consent. They may claim that by voluntarily unlocking the door after being asked, you communicated permission for further access. Now, whether that argument succeeds depends on the circumstances, but the point is that unlocking the door can create legal issues that didn't previously exist. Because of that, obtaining cooperation is often the simplest path forward, and that's why many people accidentally make things easier for an officer's investigation when they believe they're simply being helpful. The important thing to understand is that unlocking your door rarely benefits you. In many situations, it only removes a barrier that was protecting your privacy. What's interesting is that the law provides significant protections here, even though most people are unaware of them. Your vehicle is protected by the Fourth Amendment safeguards against unreasonable searches and seizures. While vehicles have different legal rules than homes, they are not free for all zones where officers can do whatever they want. The Supreme Court addressed consent issues in Florida v. Jimeno, explaining that consent searches depend on the scope of the consent that is actually given. Consent matters. The boundaries of that consent matter, and courts look carefully at what a person communicated through both words and actions. Another important case is Pennsylvania v. Mims. In that decision, the Supreme Court held that officers may order drivers out of their vehicles during lawful traffic stops for safety reasons. But many people misunderstand what that case actually means. The ruling allows officers to order you out of the vehicle. It does not automatically give them permission to search your vehicle or enter it. Then there's Carroll v. United States, one of the foundational automobile search cases. While it established important vehicle search principles, it also recognized that constitutional protections still apply. The government cannot simply ignore Fourth Amendment limitations because a vehicle is involved. But here's where things become more complicated. Officers and prosecutors often rely on additional court decisions to argue that certain actions by drivers demonstrate consent. For example, in Oliver v. United States, courts discussed circumstances where actions such as unlocking doors could be interpreted as signs of implied consent. On the other hand, courts in states including Florida, Michigan, Ohio, and Pennsylvania have recognized that keeping doors locked can communicate the opposite message that the driver is intentionally withholding consent. That distinction matters. A locked door sends a clear signal. It establishes a boundary. It communicates that you are maintaining control over access to the interior of your vehicle. Once that boundary disappears voluntarily, arguments about implied consent become much easier to make. And once officers gain additional access, the scope of their observations can expand dramatically. That's why it's important to understand what to say when the request is made. Before I give you the phrase, there's another factor you need to understand. Officers are often looking for reasons that could justify further investigation. The more access they have to the interior of your vehicle, the easier it becomes to claim they observed something, smelled something, or noticed behavior that raised concerns. Unlocking the door may provide opportunities that simply didn't exist before. So what should you do? Some people think remaining completely silent is the answer. Others think being confrontational is the answer. Neither approach is ideal. If you refuse to communicate at all, the interaction can become unnecessarily complicated. If you're hostile or aggressive, the officer may claim your behavior created safety concerns. The better approach is calm, polite, and clear. Here's the phrase, officer. I'd prefer to keep my doors locked and handle everything through the window. What documents do you need from me? That's it. Simple, respectful, direct, and it works because it accomplishes several things at once. First, it clearly communicates that you're maintaining the privacy boundary created by the locked door. Second, it shows that you're not refusing to cooperate with the traffic stop itself. Third, it demonstrates that you understand the difference between complying with lawful requests related to the stop and voluntarily providing additional access to your vehicle. You're not escalating the situation. You're not arguing. You're simply stating your preference and continuing the interaction through the window. Now let's talk about what happens if the officer pushes back. Suppose the officer responds by saying, I need you to unlock the door for officer safety. In that situation, remain calm and ask, officer, I'm cooperating through the window. What specific safety concern requires my vehicle to be unlocked during this traffic stop? That question is important because it requires the officer to explain the basis for the request. If you're recording the interaction, that explanation becomes part of the record. Of course, legitimate safety concerns can justify additional actions by officers. Nobody is saying otherwise. But a generalized request to unlock a vehicle during a routine traffic stop is not automatically justified simply because the words officer safety are used. Specific reasons matter. Now let's move to another situation that catches many drivers off guard. What if the officer orders you out of the vehicle? This is where people often make one of the biggest mistakes possible. Remember Pennsylvania v. Mims, officers generally have authority to order drivers out of vehicles during lawful traffic stops. If that happens, comply with the order. But before exiting, make sure your vehicle remains secured and locked. That step is incredibly important. Because once you're standing outside the vehicle, attention often shifts toward what happens next. Many officers will continue looking for ways to gain lawful access to the interior of the car. If the vehicle remains unlocked, prosecutors may later argue that you failed to maintain your expectation of privacy. They may claim your actions suggested consent or abandonment of certain privacy interests. You don't want ambiguity. You want your intentions to be crystal clear. So if you're ordered out, secure the vehicle before stepping away. And if the officer then says, unlock the door, after you've exited, respond with, officer, my vehicle is secured. I do not consent to entry or search unless you have a warrant or separate probable cause unrelated to the traffic stop. That statement communicates your position clearly and respectfully. Now let's discuss a common argument officers may make. They may say they need to secure the vehicle for safety reasons or check for potential weapons, but ordering someone out of a vehicle and searching that vehicle are not the same thing. This is where Arizona v. Gant becomes especially important. In Gant, the Supreme Court limited when officers can search a vehicle after occupants have been removed. The court made clear that simply removing someone from a vehicle does not automatically create authority to search it. There must be additional justification. There must be a separate legal basis. The mere fact that an officer exercised authority under Pennsylvania v. MIMS does not automatically unlock the protections recognized in Arizona v. Gant. Those are two different legal questions, and understanding that distinction can make a tremendous difference during an encounter. If the pressure continues and the officer keeps asking for access, keep your response simple and consistent. You can say, "Officer, I do not consent to any searches. My vehicle is locked, and I am maintaining my expectation of privacy. I am not granting permission for entry or a search." Notice what that statement does. It doesn't argue. It doesn't insult. It doesn't challenge the officer personally. It simply establishes your position in a way that is clear, respectful, and difficult to misunderstand. At that point, you've done what you can do. You've communicated your lack of consent. You've maintained the privacy boundary, and you've avoided accidentally creating arguments that could later be used against you. Knowing what to say ahead of time changes everything. When you're prepared, you're less likely to act out of pressure or uncertainty. You can stay calm, remain respectful, cooperate with lawful instructions, and still protect your constitutional rights at the same time. And now you know the exact phrases that can help you do it. But there's another situation that raises just as many questions. What happens when an officer doesn't ask you to unlock the door at all? What if instead they look at you and say, "Hand me your keys"? In the next video, we'll break down exactly what you should know when an officer demands your keys, the mistakes people commonly make, and the specific words that can help you protect your rights in that situation as well.